All right, well, let's jump into this. People are coming on board. It's top of the hour to respect your time. Let's get going. And I'm Paul Hitchcock. This is my colleague, Brad Barth. We're with Barth Calderon, and we are an asset protection, estate planning, business planning firm. For those of you who don't know us, we are headquartered in Orange County, California, near Disneyland. We've been in business for over 32 years. We have about 12,000 clients across the country. We have our podcast show, radio show. We're very active on social media, a very large network, and we put on about 40 events a year. Brad is a partner at the firm, a top asset protection, estate planning, business planning attorney, in high demand for talks like this across the country to groups like Vistage, the Entrepreneurs Organization, YPO, and apartment associations, and many others. And so this is going to be great. And the way we want to treat this is as interactive as it can be for you. You have access to Brad. He's very busy on the road, as you heard, talking, working with clients. And so we love Q&A. And if you could make sure to put your questions along the way in the Q&A section versus the chat, because chat's hard to track, but we can track it in the Q&A. And also, for anybody that shows up to our talks, we do give you the opportunity as a follow-up to get one-on-one with Brad on a Zoom call. Those are great. And what it allows you to do is ask any questions we can't get to here, or maybe you have a very personal situation you want to get into it with Brad. Brad's happy to do it on at a complimentary Zoom session. I'm going to put in the chat the way to get on Brad's calendar. You just can text the number. We'll get you on the calendar. So I'll put that up here in a second. Actually, let me do that right now. Make sure we have that chat. Do chat to everyone. Okay. So here's nine. Okay. All right. So if you text guard assets to that phone number there, just text it, then we'll get you booked with Brad one-on-one. Okay, Brad.
Great.
Well, let me see. We got a Q&A already here. What's
Great.
going on?
Let's do it.
Okay. Yeah. Someone's asking to turn off my camera. It must be somebody I know, one of my friends or something. I don't know. No, come on, I'm the attraction here. All right, let's get into this. So Brad, we're going to start. I'm going to follow this agenda. We'll stray from it as necessary as we get questions coming in.
Sure.
But number one is understanding the risk landscape for business owners, common threats to business owners, that the whole landscape. Can you talk a little bit about that?
Yeah, sure. First of all, thank you everyone for taking the time to spend an hour or so with Paul and I on this what we consider a very important topic. Yeah, as Paul has mentioned, I do travel nationally, speaking with business owner organizations, and this kind of question it's almost rhetorical, Paul, in its nature, as to what's the litigation landscape out there in the American business owner or real property owner. I think it goes without question that that America, I mean, just as a general statement, is probably the most litigious country in the world. And since I deal primarily with business owners, and which also includes individuals with a high profiles or portfolios of real estate, either as a business or as kind of as a side form of income production, it goes without question that the creativity of litigation counsel, plaintiffs counsel out there in holding business owners accountable for all kinds of crazy ways of liability exposure is it's unprecedented. I mean, the question you're asking is so open-ended that we wouldn't be as successful as we are as a firm in working with our business owner clients if there wasn't a need for what we do. And so it's obvious that the pendulum has swung so aggressively over the last couple, at least almost 3 decades of my career, 25 years of my career, that at least now that we have a lot of proven tools and techniques that we use, so the same legal system that that creates the environment that's ripe for litigation from all kinds of theories, employee related, tenant related, products in the stream of commerce related, regulatory related, negligence related, auto accident related, employee activity related. I mean,
Partner disputes.
partners. The list is endless. But thankfully, the system that we have that creates this cauldron of issues for our client base also gives us the same tools and techniques that we can use to guard the assets. I like your title, guard assets, because that's exactly what we do. And so it's not so much of having to deal with the individual cause of action, because those are infinite and unknown. I think the more important note here is that you have to, when you're engaging with the public, you're engaging with employees, you're engaging with tenants, liability exposure is real and it exists, and it can be devastating, not only financially, emotionally, marriages. I've seen all kinds of things happen to people over the years. And I don't think plaintiffs' attorneys truly appreciate the consequences of what they do when they
Yeah.
simply just fire off some print button and they're suing people, how it affects people. They feel completely vulnerable and taken advantage of. And so what we do is we kind of give them those guard asset techniques that not only protect all that they've worked so hard to accomplish during their lifetime, asset wise, but I tell you, Paul, there's so much more of an emotional and personal benefit to doing the things that we do, as far as
Yeah.
having that insurance policies and having the tools in place so that you're not so vulnerable. And if you do get sued, how do we get somebody out of this thing as quickly, as favorably as possible? And
Yeah.
so,
We're going to get into, yeah.
yes,
Yeah. Well
the
said. We're
the
going to get it.
landscape is rich, right? The
Yeah.
landscape is rich for
Yeah.
liability. And I think it just goes without need to go any further into it, is the need for these types of tools and techniques are necessary. Yeah.
Yeah, and Brad, we've talked about this. I mean, so me and my team, we take a lot of the calls that come into the firm every week with hair on fire calls. We get
Yeah.
about 6 or 7 a week from business owners, rental income property owners,
Yeah.
families. These are things where unforeseen liability hits. They don't have asset protection
Yeah.
and they are losing sleep. And it's insane. So literally 5 or 6, 7 of those a week we get. And I think there's about 40 million lawsuits filed in the US every year, and it's like
I'm
getting
not, I
pretty
wouldn't be
worse. Yeah.
surprised.
Yeah. Big
Yeah.
number. God, we laugh, but it's horrible.
Yeah.
All right. So, Brett, misconceptions about liability and protection,
Okay.
because
Yeah.
business owners have it both ways. They got their personal assets, they got the business assets,
Right.
but
Right.
where are people falling off a cliff
That
with
that that that's
misconceptions?
a great point. I would say misconception number one is that insurance is gonna have your back. I think that's
Yeah.
probably the number one, right? I have an insurance policy, I have a commercial liability, I have an EPLI, I have owner, no, what do you call it, the officers and directors, I have a homeowner's policy. I'm covered, because that's probably the number one source of pushback that we get. Brad, I hear what you're saying. But I have an insurance policy. But in reality, that's what I think number one misconception is, that insurance is great. And it certainly is one of the tools that we use as far as our negotiations and settlements are concerned. But insurance policies have a couple issues. They have temporal limitations and they have spatial limitations. So what I mean by that is that an insurance policy, you can say, is 30 or 40 pages, double-sided, dual column, very small 6-point font. And the first couple of pages may be all the things that you're covered for, but then the remaining 39 whatever pages are things that you're not covered for. They're called
Yeah.
exclusions. And so what happens is that I don't think people truly respect what's excluded, or what could be interpreted as excluded in their policy. So I think that's misconception number one from a spatial point of view. What's actually covered? And then the second thing is temporal. Like, at what point is it covered? Like, what happens if the policy lapses? What if the insurance company goes under? What if I'm a little late in filing my premium payment? I'm kind of caught in between a transition between two P&C carriers. And those are real problems also, and they have nothing to kind of fall back on. So I think misconception number one, it's worth mentioning, is insurance is going to have my back. And the funny thing is when you do file a claim, one of the first letters of correspondence that you get from the insurance company is, "Dear Paul, So sorry to hear about your problem, but let me remind you about the limitations and exclusions in your policy. So it's called the
Yeah.
rights and reservations letter. And so that's the way that your team is addressing you. Let's first take a big pause and let's see what we're going to cover, if anything, not to mention the adjuster coming in and kind of adjusting things downwards as far as the amount of coverages. So again, very big point. I want to make sure that one's kind of nailed. The second thing, which I think is a big misconception, is hey, don't worry, I have a corporation. Oh, don't worry, I have an LLC. So they think having one entity or maybe two entities is the silver bullet. I'm
Right.
covered. I got the LLC, I got the insurance, I'm done. Or I got the corporation, I'm done. And what they forget is that, and Paul, you know this from past talks, is that when you have an entity, we have two different things we have to look at. And I'm sure we're going to get to it as far as
Yeah.
internal liability
Right.
exposure and external liability exposure. And what clients don't realize is that you need to know who's attacking who to know whether or not that corporation is going to do you any good. And sometimes people have too many assets inside the entity. So I'll give you a very simple example. Real estate is the easiest thing because everyone can relate to it. Businesses get a little bit more complicated. But take an LLC. Okay, Brad, I have an LLC. I got my 5 properties inside there. I'm protected. Okay, maybe they have personal liability protection, but what about all of the 5 underlying assets? Asset protection, limited liability. They didn't want to spend the money on having multiple LLCs, but they put all 5 properties inside one LLC thinking that they're covered. And what they forget that once you put the properties inside, every property is now exposed to every other property's deficiencies and liabilities because it's all inside one entity. Yes, you may have personal protection, but you're going to lose everything that's inside the going concern. And so I think misconception number two is just that they think I got the company, I got the LLC, I'm good, right? And I guess number three is probably just as far as kind of order of priority, the pecking order here. I would say number three is that they fail to keep up with the formalities of these entities. And
Mm-hmm.
many times, Paul, when we're doing a kind of like our client reviews, one thing that we always do is we go online and say, what's the status? What's the status of the entity? Are you in good standing? Have you been forfeited? Was there a merger? What jurisdiction are you from? And so I think the misconception number two is that you don't keep up with the formalities of whatever that entity is, whether it's internal minutes, whether it's banking and record keeping and tax returns, intercompany loans and transactions between various companies that you may have common ownership over. And so you start getting a bit messy in the paperwork
Yeah.
and the formalities of operations. And what looks like things are separate on paper, reality is just one big enterprise based upon how you're behaving, or you just forgot to file something. And as a result, you think the company is there when in fact it's not. It was statutorily terminated. It's in suspension status because you failed to file the annual Secretary of State filing fee. So I think that's
And
kind of
Brad, so if you get sued and your formalities are crappy, like what's the outcome of that?
yeah, the
They
outcome is that, well, you remember what these entities are designed for, whether it's a corporation, an LLC, or a limited partnership, these all kind of fall under the category of a limited liability entities. And so what you're looking to do is you're saying, look, I'm willing to risk this part of an investment in this enterprise, but I formed an entity that's going to limit my personal liability. I'm putting up this firewall between the activities and me personally. And if you don't respect that firewall, you're not doing the minutes, you're not having proper accounting, you're not having proper tax returns, you're not having, like I said, formalities, you're not paying things correctly. All of a sudden, that barrier isn't there, and as a result, you may not have personal liability because they're able to pierce that corporate veil. So that's
yeah.
the consequence of being a little sloppy with the housekeeping items.
Yeah, and I think it's what led you to starting the entity maintenance
Oh
service
yeah, the
that we
EMS,
have. We were
100%.
taking
Yeah,
care of all that for
yeah,
people.
yeah,
Yeah.
yeah, yeah. That's right.
Yeah.
That's right. So see a need, fill a need. That's kind of how it works, right?
Yeah.
Yeah,
Shameless plug there. Shameless
yeah.
plug. You'll learn more about
I'll
that.
take it.
Yeah, and that's just we clients started coming to us over the years saying, "Hey, can you help with the maintenance of my entities?"
Right,
And so we do, and that
right,
and
right.
you can learn more about that with Brad. But Well, yeah, so you're picking off some great things here. Why corporate formalities matter, commingling dangers, and we're getting in now to some of the nitty-gritty, comparing LLCs, corporations, and LPs, but in particular LLCs and corporations, for business owners.
Yeah, because the LP can kind of fall within the same discussion as LLC for all
Okay.
intents and purposes. So basically, one of the main differences really has to do with a little bit historic. Historically, corporations kind of were like the main tool that people used. Even if you had a limited partnership, you typically would have a limited partnership coupled with a corporation as the general partner. But this is before LLCs became a thing. They started to become a thing probably in the late 80s. And so prior to that, all the tax backgrounds, all the legal backgrounds were all revolving around corporations, whether it's a C corporation or an S corporation. So corporations were kind of like the thing. Then in the late 18, probably 1988-ish, somewhere around there, LLCs became a thing, and they weren't quite as familiar with people either at a tax level from a CPA perspective, or even from a legal perspective, how they're going to
Yep.
hold up in court as promised. And so there was a little bit of a couple, 10 years or so until they kind of got through the court system. And now what we now have are two main tools. We have solid law, both tax and legal on corporation side and tax and legal on the LLC side. So how do we use these? Really depends. Again, goes back to, well, one thing is regulatory. In some states, specifically like California, where we're talking from, some entities cannot be LLCs because the state of California or the other regulatory says no. You can't be an LLC if you want to have to go public. For example, you have to
Like
be
a law firm, like a law
like a
firm.
law firm, right? Or you're going to go public, you got to be a C corporation. So there may be some regulatory demand that says you have to be one over the other. Otherwise, many times you wind up going into the LLC versus corporation depends upon what you're doing. And again, as I mentioned already in the previous question, well, who are we worried about? Are we worried about an activity happening inside the enterprise, like again, a tenant slipping and falling, and I'm worried about someone suing me? That's what we call that internal liability. And I'm
Yep.
looking to limit my personal liability. LLCs and corporations, very similar. But wait a second. What if I'm more concerned about asset protection? I'm worried about what if I, Paul, as a business owner, I'm driving the car on a Sunday, completely unrelated to the business enterprise, and I'm worried about my personal liability, someone reaching into my company assets, reaching into my company and foreclosing on my rental property to satisfy my personal liabilities. Now, as far as the entity, that's external. Again, remember, internal exposure, activities
Yep.
inside the enterprise, external, the owner's liability, how does it adversely affect the business? And so now, depending upon what we're worried about, that really is a determining factor on whether we go corporation versus LLC. And so it really depends if are we worried about internal exposure, external exposure? Do we have regulatory limitations? And then also you have to look at jurisdictional things, like many people online here, I'm sure, have heard about Nevada LLCs and Delaware LLCs and Wyoming LLCs and South Dakota LLCs. And there's all kinds of buzz. Like, why? If I live in
Yep.
California, how come you don't hear all about California LLCs or hear about North Dakota LLC? Why South Dakota? So there's differences in law. So the each state has ways of creating what I call, like, go back to the three little pigs analogy. If you got the big bad wolf chasing you down and you want to get the little piggy that's inside, you can have a house that's made of straw where the big bad wolf can blow it down. You could have a house that's made of sticks and the big bad wolf can blow it down. Or you can have a house of bricks where the big bad wolf can blow all day long, but he ain't blowing it down and you're not gobbling up the three little piggies. So those are the differences between the states. Some states create houses of straw. Some states create houses of sticks, and some states create houses of bricks.
It's a great
So,
analogy.
depending upon what we're trying to accomplish for our client, asset protection, well, if they all kind of cost the same, Paul, let's build a house of bricks when you don't need to have a house of sticks, or
Yeah.
in some places, a house of straw. So
Yep.
again, so that's kind of the big differences: regulatory versus what we're doing. Are we worried about internal? Are we worried about external? Is it then jurisdictional? We have advantages in LLCs that maybe corporations don't offer. So all that kind of come together really distinguishes why we may do one over the other.
Okay. All right. And yeah, we've got folks wanting us to get into solutions over risks. We're going right there. But Brad, let me ask this question. These questions are great because these will get into some solutions.
Sure.
I own a question. I own a commercial retail property in Los Angeles, California. My tenant signed the lease under a Delaware LLC and foreign registered it in California.
Hmm.
However, nothing is being conducted under the Delaware LLC. In fact, rents, insurance, certificates, business licenses, etc., are all under its California entities that are not on my lease. In addition, I was never asked to have the lease assigned, transferred to these California entities that the tenant uses pursuant the assignment and subletting provision of the lease. Brad, help me to understand what my tenant's intentions were or are.
Okay, so I can only address the structure that they have. I can't address what their intent is on things. And so it sounds to me like your tenant is let's call it, maybe they're an LLC that chose Delaware as the primary law to govern the enterprise. That's an example. They built a house of bricks. Delaware is a bricks jurisdiction. But as you properly noted, there's no activities happening in Delaware. All the activities are happening in California. So this Delaware entity needs to be authorized to do business in California, where the licensing is, the employees are, the brains of the operation. No, the accounting and banking is all taking place in California. So here you have a Delaware entity authorized to do business in California. Completely legit, no problem whatsoever. One of the benefits of being in a country, Paul, that has 50 different states, well, we have the power to choose 50 different state laws to govern our enterprise, right? It's the contract provision, it's the commerce provision of and the full faith provision of the US Constitution. Many companies, so we'll take, for example, Microsoft. They may be headquartered in Washington State, but they're a Delaware company. Delta Airlines, right? They may be headquartered in Atlanta, Georgia, but they're a Delaware company, right? Walt Disney in our own backyard. They may be located in Anaheim, California, Delaware company, right? So they're all choosing these preferred jurisdictions for a reason. But just because you choose a foreign state, foreign meaning Delaware, you have to still be authorized to do business where the activities are taking place. And from that point in view, you're a tenant who may be a Delaware enterprise authorized in California, it's perfectly fine. And whether they are complying to the terms of the lease, that's between the landlord and the tenant. But as far as them being Delaware authorized, there's nothing nefarious about that. That's just good planning. That's just smart, right?
Okay. All right. So I want to dive in as you were going through the LLCs versus corporations. But I want to get into a little bit of detail here on a solution that comes up a lot. We do a lot of these at the firm, do a lot of them, is the Plan F reorganization.
Yep. Yep.
Because I've heard you say and others speak saying if you can be an LLC, in many cases you want to be as a business because you get that
Right.
additional protection from outside liability. So can you get into a bit of how that Plan F works and what it's about?
Yeah, well, there's two different Plan Fs. We have what's called the Plan F Heavy and a Plan F Light. Let's just stick to the Plan F Light version. And that may be our own internal shorthand of basically saying it's a reorganization of an entity. So going from a corporate corporation to an LLC for whatever reason. Many times when I give talks, people are like, "Oh man, I love this LLC thing." But the person that they spoke with when they went to start the enterprise or expanded the enterprise over the years wasn't their legal counsel. They went to tax counsel. And so they now have a whole bunch of corporations or subsidiaries. And they're like, I would really like these now to be LLCs in one of these preferred brick brick jurisdictions, right? I started off in Louisiana or in Florida, and I really want to be in Delaware or Nevada, whatever. So this type of reorganization is actually it's called a conversion is probably is more correct, or a statutory merger is actually very simple to explain, Paul, because every entity, all right, has two characteristics. Now watch my hands. You have a legal characteristic, corporation, and you have a tax characteristic, S corp. I made a small business election. I am a corporation, tax as an S, or I'm a corporation, taxed as a C, right? So you got the legal status and the tax status, EIN numbers, etc. So what we basically do during these conversion processes, we only change the legal status. We don't touch the tax status. So I like to say, I'm taking off my corporate jacket and I'm putting on an LLC jacket. I didn't change the soul of the body on the inside. The assets didn't change, the liabilities didn't change, the obligations, the employees, bank accounts, there was no distribution of it. It's the same person. I just switched from corporation to LLC, and that's called a conversion or statutory merger. Every state has some mechanism to do that, and it's all not that complicated. So what happens first, we'll just use California as an example, because I'm most familiar with that. So I went from a California S to a California LLC. Great, but I still have a house of straw, right? So then once I did my conversion, now that I'm in California LLC, taxed as an S, same bank account, same EINs, etc. Now I go knock on the door of Delaware, Nevada, South Dakota, or wherever, and say I now want to merge my company with. I want to become a Delaware LLC, like the tenant we just spoke about, but I
Yep.
have to be reauthorized to do business back in California. So the end result of all of that paper shifting is you went from a California S corporation to a California LLC. Pretty simple. Then you convert to a Delaware authorized in California LLC. And that's what a lot of our clients do. Not that it requires proper paperwork. You may need to let some of your vendors know what's kind of going on here, but basically it's a big nothing burger depending on how it's done and what type of activity that what type of activity vendors and sureties and banks that you may be worth getting everyone kind of on board with a feasibility study, but otherwise it's not that big of a deal once it's greenlit.
Okay. Okay. Holding companies and operating companies, when do you it's, the topic is when to separate functions
Okay,
there.
that's also a great question. So, there's two things to think about. Remember, you have assets and you have liabilities, and this is what I was telling you earlier about the client thinking they have the silver bullet. Like I have the company, Brad. I don't need all this fancy stuff. I have a company, but what they forget is what's inside the company, right? They have not only the real estate, the equipment, the inventory, the ARs, the cash reserves, building one, building two, that's inside the corporation. And well, what else is in the corporation? Well, I got my contract obligations, my employees, my drivers, my sexually harassing supervisors, right? All of this is now inside the corporation that they think is the silver bullet. So this is an area now where you have a mixed bag of assets and liabilities.
Mm-hmm.
So to where we can, again, feasibility wise, we want to separate the asset side from the liability side. And I can go example after example, but one always comes to mind. The guy says to me, Brad, I'm one auto accident away on the 5 freeway from losing everything. And he's in a
From a driver in
from
the
a
company.
driver,
Yeah.
high risk business, right? From the driver. So what we did is we wound up pulling everything, all the assets out. So God forbid he does have that driver accident. The guy has some liability insurance to help minimize it. Worst case scenario, you fire up a new operating company, you reconnect all the assets, and bada boom, the guy's back in business, even though he had this terrible event because you're able to separate out. And now the metric for that basically is very simple. It's setting up entities and maintaining them really isn't all that expensive, especially when you're talking about a going concern basis. And so now it's just a matter of what's the appropriate number of buckets to hold the asset side and how many different buckets do you need for operations side, right? That's what you're talking about, separating out like management structures, employment structures from asset structures, the real estate, the operating, the equipment, the intellectual property, the cash reserves, the ARs. Can we separate those? Again, part of a feasibility analysis, and the answer
Yep.
is yes. And it can be done in a tax neutral way as well. But again, it all depends on a case by case basis.
Brad, I've heard you mention before, companies that are carrying a lot of cash in the
Yep.
corporation, for example, not a good idea. I mean, I'm
Not a good idea.
talking, yeah,
Yeah.
cash beyond operating use. And so you're stripping that out into like a stocks bonds cash LLC over here, or what
Yeah,
is that
well,
about?
there are a variety of vehicles, but I think that the heart of what you're getting at again goes back to our my silver bullet corporation, right? Your mixed bag of assets and liabilities. Well, sometimes your running operating account has a lot of money in there. I have a lot of clients, the business owners, they're just nervous people. They're nervous Nellies. I like having $1 million on the books for cash in case I have a down quarter or employee ish. I like, okay, but I only need, let's just say 400,000 to maintain my ordinary operations and obligations. In other words, they have in my example, $600,000 more cash than they need to keep the company solvent, right? For
Yeah,
its purpose. But it makes them feel good. Okay, great. But the
right.
problem is they get sued that all those monies are attachable by a creditor on the because what again the Tasmanian devil is on the inside, and one of the things they can go after is the cash. So if you don't need to keep $1 million for your ordinary operations and obligations, but you do have to keep 400,000, then let's remove the other 600,000 or however my math was. I said six and four and
Yeah,
four,
yeah.
whatever I said. Take out the extra amount, right? And that way the company is running correctly. It's solvent, but it's not overly funded with too much cash. But if the clients, if I really like the $1 million in there, then fine. Then you can put back a secured promissory note back in. Now those extra 600,000 that now you're lending it back can be perfected by a UCC filing or a deed of trust against the property. At least now that extra cash is collateralized and has an encumbrance where you get paid back first. So if you do have that internal driver accident we just talked about, you're not going to lose your extra cash. So
Oh,
again, and how we do it, Paul, what mechanisms does the company use, whether it's a stocks, bonds, cash LLC, whether it's a similar type of trust that the company can establish, that's a to be determined. But the point of all this is you don't want to operate too fat, right? You want to operate solvent correctly. And if you really want to put extra money in, which every business owner does as part of, I mean, every business owner I have ever spoken to has at one point put personal funds into the company. Let's secure it and perfect it to protect you. Right. That's what I do.
got it. Okay. And these questions that are coming in, I think, are related to this. How are retained earnings viewed by a hostile entity? And then I believe I have an excessive amount of retained earnings with limited amount of cash.
Yeah. Yeah. So that's the whole point. I mean, the retained earnings, you need enough for your ordinary operations and obligations. I'd probably say for about 1 quarter, about 3 months is kind of like I think the good rule of thumb. So you want at least, and that's also considering your ARs coming in, your 90-day receivables coming in. So if you're able to maintain $400,000, considering good ARs coming in, again, you don't have to keep $1 million in there. That's all. And how do you especially if you're a disregarded entity, a partnership or an S corporation, you're already being taxed on that money anyway. So you don't necessarily have to keep it inside there again, absent like my client example being the nervous Nelly, they want the extra cash, fine. Then we just got to find a way to collateralize that to protect it from a claim of an internal creditor. So again, it's just a matter of finding the right means of doing it. There's a lot of ways of pulling money out, equity stripping, creating friendly liens, having other unfunded liabilities. There's all kinds of ways, and that's part of what our discussion with our clients are. How do we creatively, first of all, find the right dollar amount, and then how do we creatively basically get that money down to where it's a not too much of a too much of an attractive asset. Because again, cash heavy, not a problem, but you also want to consider good ARs coming in, right? So that's again, that's just the facts and circumstances analysis.
My friend and I own a residential income property with tenants in California. We want to take the property out of our names. We have a low interest Fannie Mae loan on this property, which we do not want to lose because of due on sale clause. Do you
Right.
recommend a California LLC or Wyoming LLC taxed as a partnership? What are the benefits of Wyoming over California for holding title to this residential income property in California? Lastly, we do not want to trigger reassessment of property taxes because of our low basis.
Yeah, perfect. Great question. That's a great question. A bunch in there. Great question. So the first thing is this goes back to the California versus the Wyoming or Nevada or the examples. This is just your house of straw versus house of bricks. So that's so converting out of California for the benefit of a more stronger preferred jurisdiction. Great. But since the dirt is in California, whatever primary jurisdiction that you use, you're going to have to be registered back in California. So in my example, Nevada authorized in California. Okay, easy. You fixed one problem. The second thing is, how do you do it without triggering property tax on Prop 13? Again, not a problem. There are specific exclusions under the facts that you're presenting that would prevent the Secretary of State, I'm sorry, the Board of Equalization from exercising a reassessment on the property based upon what you're sharing with us and how we design the LLCs. So again, not a problem. Number two. Number three is the more interesting one, as far as the due on sale clause with the lender. So, especially when you have a favorable interest rate, for example, if you happen to get one of these really sweet COVID rates, and all of a sudden now the interest rates are much higher, you don't want to even look at the property in fear of them trying to force a refinance at a higher rate. So there are clever ways of doing that, and there are other tools. I don't want to get into too much detail here, but there are other tools that we use that qualify for what's called the Garn-St. Germain Act, and that's a federal law that says so long as you're using this particular tool and it's done correctly, that banks are prohibited under federal law from exercising due on sale, even though we did have a little bit of a change of ownership as far as restructuring it from individuals to an entity. It's how you do that to make sure you want to tick all those things. You get the better state jurisdiction. You don't want to trip Prop 13 reassessment, and you don't want to upset your lender with a due on sale clause. And again, that's why you want to, don't do this at home, kids, type of thing. So
Yeah, yeah,
you want to work with a professional to get that done, and we can certainly do that for you.
yeah. Okay, so Brett, does this come up a lot of the domestic and offshore trust?
Yep.
I know years ago, I don't think there was a lot of choices to go domestic. It's growing that business maybe, but how do you answer that? When is it appropriate to look
Great.
offshore, and what's the
Great
whole deal
question.
there?
Great question. So not only that, but I was actually on the board of legal advisors for Southpac Trust Company out in the Cook Islands for many years. I spoke on their behalf internationally as well as domestically in the Bahamas and other states. And I've also even trained on their behalf other attorneys on how to use foreign asset protection trusts. So you're right. Back in the day, we'll say pre 9/11. That's how far I'm going back. I started my practice with my father back in 1997. So I had probably a good X numbers of years beforehand of the pre 9/11 of doing, and you're right, it was almost exclusively international Cook Islands asset protection trust. The domestic stuff simply just didn't hold up when you had that. Then came 9/11. And then you had the Patriot Act, all about 2001. And a handful of years later, as that kind of made its way through the banking system, maybe 2005 or so, it started having practical implications for clients where, yes, you can set up these domestic structures, but the level of scrutiny that they were getting because everyone was freaking out because of the Patriot Act. Well, of course, you're only a terrorist and you're only a drug dealer or you're only a money launderer. Why else would you have an international trust? I mean, so that's what was getting in the public's mind. And not only from a banking point of view, but also in dealing with businesses and business partners. So now all of a sudden, your international trust, although the best, just were having practical ramifications that made them really unusable. So thankfully, many states, starting with Alaska, followed by Nevada, and then you have there's about 13 to 15 states, and we only use Nevada exclusively, not only because of our relationship, but also because of the precedent that they've established. Domestic trusts and laws have really, really stepped up. So now, to minimize all these tax problems and due diligence issues and the appearance of taint with the foreign stuff, most of our clients, I'm gonna say most, like 90% of our proactively planning clients create Nevada asset protection trusts. Now, doesn't mean that you eliminate the use of a foreign trust. It just means that you got to pick and choose the proper tool, right? Depending upon the need, which tool do we use? Well, proactive clients don't have okay, Nevada domestic, great. You're not running away from a client, a plaintiff, and everything is fine. But then you do have circumstances, Paul, where it's like the old proverbial Hail Mary pass, right? It's like I, it's it's you need to have something greater, right? And those are still available to us. Or we have clients that have a little bit of a mix. They'll do the foreign structure and a Nevada structure. Just back because the foreign structure is theirs. It's their money, their nest egg, right? They want to do international investing. They're not worried about banking and lending of business partners. It's their money. We'll call that that's their what do you call it? Their nest egg money, whatever
Yeah.
percentages. Then you have the money that they use for businesses and interactions and banking. Okay, that's a domestic structure. So some clients do a little bit of both. The international thing is only an issue when you have to interact with a lot of other domestic entities. And so we normally would set up a domestic structure. It doesn't mean that you eliminate the use of international. It just means that you have to make sure that if you're going to go that direction, you just got to make sure that they say the benefits outweigh the burdens, so to speak. Now, no,
Hmm.
logistically, practically, and financially. That's all. But
Yep.
they're both viable. Like anything, you got to have the proper tool for the job. That's all.
Hmm.
Yeah.
hmm All right. Scenario, attendee says trade contractor has substantial line of credit with bank who has an all-inclusive UCC filing and personal guarantee. If I move my investment brokerage accounts into a trust, are they going to take exception to this move?
No, well, it depends on who's collateralizing who, right? So if they have a UCC against the company assets and part of that was the ARs or the cash reserves, then yeah, that may be an issue because that's part of what's been collateralized by the UCC. Again, I don't know. I don't know. That's a very fact sensitive thing, but the UCCs and personal guarantees, because when you may have presented yourself a certain way for them to lend money to you, for example, and now all of a sudden you present them a financial statement 3 or 4 years later that's redesigned with LLCs and trusts and whatnot. Well, remember the time that you signed the paperwork, you looked one way, and now you look different. So their UCC and their guarantees are good for them, but your new structure would be good against somebody in the future, right? You have a pre-existing creditor versus an unknown, unascertained creditor. So you got two completely different fact scenarios. So that's a depends. So that's one of those areas where you can't present yourself one way, Paul. Like, hey, I have everything in my name and you can take everything and I promise to pay you back. Lend me $1 million. Then the next day you go to someone like myself, and next thing you know, we turn an apple into an orange,
Yeah.
right? And now you default on the loan and you say, you can't touch me because I'm now an orange. Well, no,
Right.
as far as they're concerned, you're still an apple because that's how you presented yourself as an apple, right? So that's a pre-existing creditor. You can't just defraud your creditors. But as far as anybody in the future, you're an orange, right? So
Yep.
it's different. You got to respect the timeline.
Okay. No, very good. I'll just reiterate, somebody's asking here to get one-on-one with Brad again, if you it's in the chat, if you text guard assets to the phone number in there, it takes you to a form. You just put your name and email on there, then you'll get booked. But we hopefully make that easy for you. Text guard assets to that number. Under what circumstances, Brad, question, would you utilize a South Dakota trust?
In all of my years, we're talking 25 plus, yeah, I'm on my 25th, I think 26th year of practice. I think I've done one. Um, the reason why we've done one is because we have greater contacts with folks in Nevada. So I think I've done one in Nevada, I've done a couple in Alaska, done a couple in Tennessee, I've done one in Hawaii, but the majority of them, hundreds and hundreds of them, really are in Nevada. And the reason why is when you look at the state rankings of all of us of what are called spendthrift trust jurisdictions. These are the states that allow for these types of wealth preservation trusts. Nevada historically and consistently ranks number one, always the best, even a drop above South Dakota, where South Dakota may come up as a 98, Nevada 99. So and there's a clear difference as to why that is. And so remember what we're trying to do is we're trying to build the strongest fortress for our clients. And so we're going to always pick the jurisdictions that are the best, and we're going to invest our time professionally in establishing relationships and working knowledge with those best jurisdictions. It doesn't mean that South Dakota isn't an option for you. It certainly is, especially if you live in South Dakota. Great. But if you have an option, if there's a toss up between South Dakota and Nevada, I'd go Nevada, right?
Yeah.
Because it's better, right? And then I look at it again from a relationship, a professional relationship point of view. And those of you online here who work with vendors and people, you know that a lot gets done just based upon relationships and rapport that you have with your vendors. And we have very strong rapport with our vendors to the point where I can WhatsApp the owner of a particular trust company and I can say, hey, I need this done tomorrow. And guess what? It gets done tomorrow because
Hmm.
I have that relationship with the people at the top because we've invested in that over the years, which makes life easy for us as the advisor, makes
Yeah.
life easy for the client. I don't have that in those other states because we don't do enough business there. And because of the volume that we do, we get discounted rates, we get top tier service from them. And so for those reasons, again, not only is it the best, but also just professionally and how we just have to navigate those waters. It's just easier for us to use Nevada versus South Dakota.
Okay. Question back to holding company. Can I have an out-of-state holding company, Wyoming, that owns my multiple companies as a shield? When does it make sense to have a holding company?
100%, no problem. Perfect. Perfect. The answer is yes. So having a holding company that holds a bunch of underlying let's say you have well, let's go again. I'm just most familiar with California LLC, one, two, three, four. You got four of those, and you put a Nevada or a Wyoming holding company up on top. Great. All that does is who the owner is. Or again, remember, external liability, you put a house of bricks around your California structure without necessarily the need of having to convert all four of our California LLCs, if that's uh, advisable, as opposed to converting each of the Californias to Nevada. Again, it depends on what we're trying to accomplish. But to answer your question, the answer is yes. So yes, you can do that as part of a holding company, Wyoming, Nevada, etc. The question is now, what do you do with that holding company, right? Is it operating? Is it non-operating? Is it in your name? Is it in your trust? Is it an asset protection trust? What do you do with that? So that's kind of like the next follow-up question. Again, that goes back to what's the desired outcome of that plan? What are we trying to accomplish?
Yeah.
And that kind of helps steer the conversation. But just based on the facts, no problem with doing it that way.
Yeah. Yeah. Okay. Well, this is a good one because you look at this a little bit differently, a little bit higher end is a buy-sell agreement and
Yep.
operating agreements for
Yep.
business. Now, you've talked about asset protection provisions within there, but could you comment on that, on how you look at that for a business owner?
Oh yeah, great. So not only am I asset protection attorney, Paul, I'm also an estate planning attorney, right? So we do a lot of business succession issues. A big part of a business owner's estate plan must include a buy-sell agreement as a control mechanism. Most people are familiar with what a divorce is, right? And you're familiar with a premarital agreement or even a post-marital agreement where you try to work out these terms while you're still talking, in the unlikely event that there's a separation, right? Things are a little bit easier to kind of let the chips fall more controlled. Well, it's no different with business owners. Business owners also have a child, right? It's the business, their blood, sweat, and tears, emotions. Sometimes they love their business more than they love their family. Right? So we have to make sure that if something happens among the business partners, they become incapacitated, they lose citizenship, maybe for tax purposes, maybe there's an act of moral turpitude that happens that affects the company, maybe there's an incapacity, a disability, a death. We need to make sure that that company stays wholly owned within the intended owners. Because otherwise, Paul, what does your estate plan say? What does my estate plan say? Hey, when Brad drops dead, everything that I own goes to my wife, my
Yeah,
darling
yeah.
wife. Okay, so Paul, you and I are great business people. We get along great, right? And we're successful and we got law firms and marketing companies and everything is great. I hate your wife and you hate my wife, right? But what happens now is
You know, I love Tina, by the way. You
I
know, I
know,
love
and I
Tina.
love my wife too. I love Tina too. She's great. In case she's watching. So, but now all of a sudden I become incapacitated. Who now is acting as my power of attorney? My wife, Tina. And guess what, Paul? Now you're in business with my wife, Tina,
Yeah,
while I'm incapacitated, disabled. Or then I drop dead, right? Who inherits all my stuff? Everything goes to my darling wife, Tina. Now here again, or it's not Tina. Maybe, God forbid, Bina and I both pass away. Now you're in business with Jessica, my daughter, who doesn't know the first darn thing about what we're doing.
yeah, yeah.
Right. So now you have all these unintended consequences between spouses and adult kids and nieces and nephews. And you're like, now you're in business with these people, and that's a train wreck disaster. So part of a voluntary or involuntary exit of your business, again, voluntary or involuntary, you got to set these terms up in advance. You got to have the marital agreement. What happens when you die? What happens when you become incapacitated? It doesn't mean that Tina you has to control everything. Maybe Paul, maybe my dad is the best person for you to step in my shoes to interact with you as far as the business. But
Yeah.
my wife takes care of the household and my taxes and lawyers and collecting government benefits and all the things that on a personal, but she doesn't know the first darn thing about the company. So somebody else, my CFO, my CEO, my key employee, maybe that person's the best person to step in. And those buy-sell agreements, those control agreements manage that. And I've seen the difference between successful succession or disaster companies is the difference between having a buy-sell and not having a buy-sell. All right. So
Hmm.
it's completely necessary whenever you have any member outside the family that is
Yeah.
outside husband and wife owners,
If
kids, business partners, sister brothers, parents. Whenever you have a non-spousal partner, you better have something like this in place. Otherwise, it's a ticking time bomb.
okay. What a question. Once you place everything I own in a house of bricks, what do I do when I get served with a lawsuit in the future? Do I forward the summons to you, the attorney, in order to inform the plaintiff's attorney that I am bulletproof? Like what actually
Yeah, so
transpires there?
that's again, great question. Again, it depends upon where we holding again. Remember, where is the bullet coming from? Is the bullet inside the brick house or is the bullet outside the brick house? So you first got to start there. And so where is the attack coming from? So the first thing that you do is you submit the claim, the complaint to your insurance company. That's the first thing. So whether it's a business related activity, it goes to the insurance company, or whether it's a personal, you'd send it to your homeowners or your auto insurance policy carrier. They typically will then designate an attorney to represent you. Now that those are, we'll call them the lieutenants. They are the ones that are on the front line fighting a good fight on your behalf based upon the terms of the policy. Now, sometimes those lieutenants don't quite know the terrain that they're fighting within. What are the
Mhm.
strengths and what are the weaknesses based upon this preservation structure you put together? That's where we come in. So many times, what we're doing is that we're advising your counsel how
Ah,
to best utilize the plan that you put together in advance. Because again, they may not know the nuances of all the. They're great in what they do, right? I can't litigate a case, right? I'm so far removed from that. But we advise them on how to use the system to their advantage. Because what's the goal? The goal again is to get you out of this thing as quickly and as favorably as possible. So we need to make sure that your lieutenants, your people, your boots on the ground have the appropriate strengths and weaknesses where they can push or give based upon the circumstances. So while we are not the litigators, we counsel the litigators on your behalf.
Got it. Okay, I'm just putting up in the chat there because you remind me of it. That's our YouTube channel, Wealth Protector TV. If you're not, for those listening, subscribe to that. We put fresh new videos every week, teaching, guiding, helping from all of our attorneys up there. It's a great channel, but Brad just reminded me because we, a few years back, recorded a session of your dad, Harry Barth, who's the founder of the firm, with Martin Greenbaum, who's
Yep,
got
that
the
was great.
largest.
Yeah, I share that all the time with people. It's a great video.
It's a great video. That video is Martin Greenbaum, friends of the firm, great guy, owns one of the largest collection law
Yeah,
firms,
debt
you know,
collector. Yeah,
debt collector. He's an attorney. That guy's a terminator. If he gets a hold of a judgment, he's going after you. He will go to your deathbed and take it. That's what you're up against. And that's why Brad says we know what we're doing. And Martin goes through that video, which is on our YouTube site, of how he gets to your assets
yeah,
if they're not structured properly. Anyways, it's
right,
a good
right.
one.
Yeah.
All right. So as we're getting close here to the window, just a couple other things here. Um, is okay. Yeah, well, business partner conflicts and exit planning. How do you wall off conflict with your business partner? Like when you were talking before, I was thinking about it. If your business partner has a liability over here,
Yep.
and they're getting sued for
Right,
something,
right.
what
And
what do
that's
you?
and that right. So that goes down to any entity, whether it's a corporation and you got shareholder issues, or you're an LLC and you got member issues, or a limited partnership and you got limited partner issues. The idea is that each member, shareholder, limited partner are not personally responsible for the acts of the other member, shareholder, and or general part, whatever partner. Okay,
Yeah,
so the idea is that if someone's coming in and they're already a mixed bag of liability, just because you're going to business with them doesn't mean that you yourself are automatically going to be owning their liabilities. You're not buying their liabilities. However, you do have to be aware that whatever they're doing, it's their membership interest, their stock, or their limited partnership is comprises their assets, right? So you may be in partnership now with somebody where you're coming in as a clean slate and they're kind of like a mixed bag of trouble. Well, if one of their creditors is attacking their interest, although they may not necessarily be able to interfere too much, you're still going to have to deal with that like collaterally or ancillarily. You know what I'm saying?
yeah,
Right. So although it's not a direct problem, one of the but by walling it off is one of the good things that you can do. But just remember, depending upon again, walls of sticks versus walls of straw versus corporations, internal, you got to look at it holistically and see where's the problem and how do we wall you off from that. The answer is yes, you certainly can do that. Sometimes it's a very simple fix. Sometimes it's a matter of just restructuring your personal holdings. But yeah, it can be done. But again, you have to look at it holistically to make sure that we're pinpointing the proper issue and coming up with the proper solution. All right.
yeah. And this is a good question. We'll kind of taper off here, but uh, Tenny's asking if when you assess the situation, is it the most efficient planning for me? Is there such a thing as too much asset protection?
Oh yeah, 100%, hundred
Yeah,
percent. Yeah,
yeah,
you really, and I've seen that. I've seen people, we'll call them like the internet warriors and the garage mechanics guys that go crazy, right? So they really kind of make themselves bonkers. And now in the world of AI, I've even fiddled with it myself. It's like, whoa, that's crazy.
yeah, yeah,
It's like so they overly complicate things, and this goes back to one of the very first things we talked about. If you overly complicate it by putting too many layers of the onions. You have too many points of failure for lack of follow-up and formality. So again, it
hmm
kind of goes back to that entity maintenance thing. You got to maintain the structure, otherwise the whole house of cards comes tumbling down. And remember also, you need to have legitimate business purposes behind each entity. You can't just create entities and throw them around like whatever, like playing cards, you know. They each have to have a legitimate business purpose behind this. So part of the plan is not just creating the boxes, Paul, but you also need to build a narrative around that so that you have a reason on why this is being done, whether it's estate planning, succession planning, business reorganization, tax minimization, centralized management structuring, getting kids involved in gifting. So you got to have reasons behind why you have. And asset protection doesn't mean multiples of layers.
Yeah.
Like you can have 10 houses of straw, right?
Yeah.
Or you can have one house of bricks. Which do you prefer, right?
Right.
I like
Right.
watching these YouTube videos. There's a guy who likes to say, well, I have this AR-15 gun. How many pieces of drywall can it go through before it stops a bullet, right? So he'll lay up like 100 pieces of drywall and it goes, okay, how many iron cast pans will it go through this? All right, so you see,
I've
so
seen that. I've seen
right, so
that.
it goes through 50 layers of drywall, but one pan. Right, right. It stops that bullet. So again, it doesn't, so it's not a matter of layering complications where you yourself can't manage it. Your CPA can't manage it. Your CFO can't manage it. Oh, and God forbid, your spouse can't manage it, right? They're going to yell at you,
Right.
right? So it's not a matter of complication. It's a matter of effectiveness and narrowly targeting, again, what the desired outcome is.
So,
Smart, right?
so what do you do, Brad? When you get on a Zoom with somebody for the initial thing, what are, are you all ears? Are you listening? Like, what are you
Yeah.
doing?
Yeah,
Yeah.
well, that's it. Well, first of all, we always request a personal financial statement. So that way I have an idea of what we're talking about. If we're going to be talking about estate planning or asset protection planning, okay, what are we working with here? I need to know what you got so we can have an effective conversation. I have a secure link that people can send stuff to me, so it's confidential, attorney-client communication privilege, etc. That's so first thing I take a look and I already have in my mind based upon what you got how things should be structured. There are proper ways of doing this. Now I get to hear your story. What is it who are we worried about? Are we worried about internal people, external people? Are you married? Do you have kids? How old are you? Do you got a business partner? Are you a slumlord? Do you have multiple are they commercial properties? Are they so now I'm listening, I'm getting the facts. I'm assessing
Yeah.
what's going on here because now it's a matter of risk analysis, right? What's the liability profile that the client has? And now is the liability asset related? Is the or is it personal related? And so these are the things that you look at, and then that plan that I had in my mind based on your PFS now all of a sudden starts getting changed and manipulated. So now that the end resulting plan, at least the proposed plan, now is more specifically tuned to what the client wants, right?
Right.
Now
Right.
the next question, can we do that? Right? Is it feasible based upon whatever it is? And that's how it goes, right? That's how it
Yeah.
goes.
Yeah. And someone's asking, and I know your travel schedules are all over sometimes about meeting with you in
Yep.
person.
Yep.
And if you're not in the office, I mean, I suppose they could come into the office, have you on a Zoom,
Yep.
see the
Yep.
office,
Yep.
and
Yep.
you know, how would you?
Yeah,
Is that
yeah,
how you do
I am a virtual attorney. So I'm like your AI guy, right? So right. So
it?
uh, I moved and I've been working from home now for almost 5 years. I do travel a lot, but doesn't mean that we do have a beautiful building in Orange, California on the 20th floor of an A-class building where we do have a lot of attorneys and support staff. So although for fulfillment, for notaries, for coming in and meeting people, or just want a beautiful view of Orange County, there it is. There's the build that Paul has up there. You can come into that building. I spent about a good 15 years on that 20th floor, and I was very happy when I finally could work from home. But thankfully, nowadays, with modern technology and Zooms and emails, I have found no problem with working with my clients on an online basis. I do travel, as Paul mentioned. I do a lot of travel, and so I try to make sure my clients are staggered in such a way where it doesn't necessarily mean that there's a delay in deliverables because I'm not a one man band. We have about 34 personnel that make up the team at Barth Calderon, consisting of attorneys as well as a paralegal and support staff. And besides, if you're working with me, you're not just working with Brad here out of a garage. You're working with the entire organization of Barth Calderon. And so you will be contacted through my 2 or 3 paralegals and my 2 or 3 support attorneys. And sometimes it's a bit overwhelming because clients are saying, I'm getting from Danielle, I'm getting from Shalmeet, I'm getting from Lisa, I'm getting from this person. Well, yeah, Dad, everyone's working together on your plan, but ultimately everything is funneling through me. I'm the conductor of the orchestra here. I'm the
Quarterbacking the
one
thing.
I'm the one that does all this. I review everything. I discuss, I plan, I put everyone in order and tell them to march. We try to get things as coordinated as possible so the client isn't overwhelmed. But ultimately, if they want to go into the office and sit down with Danielle and notarize documents and have someone flip pages for you, great. But otherwise, you're working with me online. Document review is done here on Zoom. It's great. And that's kind of how it's worked. It's been very effective for almost 5 years now, and I hope it continues this way.
Yeah, great. Awesome, Brad. I know you're busy. Thank you for doing this. I want to thank everybody for being here. Really appreciate it. Stay tuned via email because we're doing these more. Actually, we got one coming up next month on taking care of key employees and key executives. So David Calderon will be doing that one. Appreciate it, and we'll see y'all real soon.
Great. Thanks, Paul. Thanks to
All
everyone
right.
for your attention. Okay. Bye bye.
Right.